behind supporting your office in order to institute this capacity, especially for the Philippines.
Yes.
And pretty soon you envision that this center will become an arbitration center for all, I mean, at least Southeast Asian, well, disputes. Is that a vision for the
We're
arbitration
looking,
office?
well, that's a possibility. But when we were launching this project, when we were discussing, our primary concern really was the local stakeholders. Of course, as you know, you're with us in IPO, we have like 400 cases or 500 cases right now.
Pending. Right?
Pending, yes. And of course, we have the special commercial courts here in the Philippines, and they have IP cases themselves. And we want to declog the system. We want to offer the public a better option. No, well, not really an option, a better option, but a different route for them, especially if you're dealing with time-sensitive cases or like trade secrets wherein you cannot really divulge a lot of information to the public. Arbitration would offer you a very confidential forum. So,
Okay, so that's what the IPO is offering. All right, ladies and gentlemen, there you have it. We have the basics of arbitration as an alternative to litigation. Usually, it's a common complaint that our judicial system is clogged with cases and it takes substantial amount of time for cases to get resolved. And usually, when it comes to intellectual property cases, we're talking business, where time is of the essence. Hindi naman pwedeng you'll stop doing business just so you can finish the case and have the decision enforced. So the IPO bill is offering this alternative mechanism for all litigants in order to speed up the resolution of your disputes. Please don't go away. We'll be right back.
bilisan.
Everything we listen to, everything we watch, everything we read, everything we wear. Behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment. Making life interesting. Enjoy their efforts. Respect them. They help shape our world. Everything we listen to, everything we watch, everything we read, everything we wear. Behind all our favorite things, there is an author, an artist, an inventor. Genuine, real, original. Pushing the limits of imagination and innovation for our comfort, our enjoyment. Making life interesting. Enjoy their efforts. Respect them. They help shape our world.
Back to intellectual property. As that video clip said, behind all our favorite things, there is an author. Respect them and use their intellectual property properly. Tonight, we're talking about arbitration with Attorney Lope Manuel Jr., the head of the Arbitration Office of the Intellectual Property Office of the Philippines. Attorney Manuel, or should I say June? Or
June
Lope?
is okay.
June is okay, okay. Earlier you said when parties opt or decide to go into arbitration, they can choose their judge or their arbitrator.
Yes.
So, do you have a list? I mean, can just anyone be an arbitrator, or do you provide recommended names for them to choose from?
In the IPO, we have an accredited pool of arbitrators. As I've mentioned, as I'm discussing earlier, we had a training for arbitrators who are experts in IP, and we also had a training for arbitrators who are expert in arbitration, in training them for intellectual property rights. Yes.
These arbitrators are all lawyers.
Not all of them are lawyers. Some
Ano?
of them are scientists. Some of them are engineers, because this is a specialized form of alternative dispute resolution. So we have to have a diverse pool.
You need to have people with technical background
Yes,
to
exactly,
understand
yes.
pharmaceutical, for example, or brands.
Yes, that's true. Like, for example, if you discover the medicine and there is an infringement of your discovery from another inventor, of course, you want your arbitrator to be knowledgeable in what you do. You'll be more confident to appoint an arbitrator who understands your language, like maybe the language of science. I'm not really a scientist, but you know, some of the scientists, they speak their own language. So it's better for you, if you're litigating a case or if you're arbitrating a case, to appoint someone who understands your language.
Let's take a concrete example. Well, hypothetically, for example, I'm a brand, I'm McDonald's or
Okay.
McDonald's.
Okay.
And then I'm a franchise holder, meaning I am licensed by the main franchisor
Yes, yes.
to use the trademark and then the recipes and everything. And for example, they come here and then sue me, for example, for violation of the franchise contract
Okay,
or violation
yes.
of the use of the trademark. At what point can we both go into arbitration? For example, the case is already filed
Okay.
in the IPO or in the courts. It's a civil case, for example, for improper use of trademark. At what point can we go into arbitration?
Okay. Like, Sarah, in arbitration, there is a there is a pre-conflict arbitration and there is a post-conflict arbitration. If, for example, you enter into a franchise agreement, usually the lawyers, I think most of the lawyers who are watching the show would agree that you put on an arbitration clause in a franchise agreement, especially if it's an international agreement. And most of the time they put, if there's a conflict between the parties, we agree to arbitrate in Hong Kong using New York law or something like that.
So you choose the venue and then the
law,
yes.
governing law
in the
law,
arbitration
in the arbitration
clause,
clause,
in the contract,
in the contract,
even
yes.
before the problem arises.
Yes, even before that. If you have that, there's no problem because the court will just issue an order directing the parties to arbitrate depending on how they agreed, like the number of arbitrators, where to arbitrate, the applicable law. If, for example, you don't have that kind of clause, you can enter into an arbitration agreement. In the IPO field, we design an arbitration contract where the parties can enter into an agreement even while they're litigating. So, for example, if they file a case in the IPO field, in the middle of all these proceedings, they decided, oh, maybe we should go to arbitration because I don't want to wait. I only have like 3 months time to sell this product, and after 3 months, it's not going to be as effective or as profitable. So you enter into an arbitration for like, say, 1 week. You can do that. You can enter into an arbitration contract.
So
and we can facilitate it.
So as you said, everything depends on the parties. It's whether there's no conflict yet or where a conflict has already arisen and is already pending in the Intellectual Property Office. They can choose to go into arbitration.
Yes, that's true.
And what happens to the case that is pending in the Intellectual Property
Well,
Office?
under the ADR Act, it says there that if there is an arbitration contract or arbitration clause, the case should be suspended and should be referred to arbitration. If it is a post-conflict arbitration agreement, what we practice in the IPO is to suspend the case.
So you suspend the case.
No, I'm sorry,
go
to
forward.
dismiss the case.
You dismiss
Yes,
the
and
case.
and refer it to the arbitration proceedings. And what you can do, for example, if you need assistance on asking the witness to appear before the arbitral proceedings, you can request provisional remedies in the court.
In the court.
In the court.
Okay.
Yes.
When it comes to the arbitrator, he or she acts like a judge,
Yes,
more or
yes,
less.
yes.
So he or she hears out the parties and everything. They have to be accredited, well trained by the IPO.
By the IPO.
Otherwise, they're
PDRCI.
not in the list.
Yes, otherwise they're not in the list. But I just want to say that our rules is very flexible. It could provide a provision that if a case is highly specialized, there might be an instance where we can allow someone outside the pool to be appointed as an arbitrator. But that is some of the exceptional cases.
It's an exceptional
yes.
case. But usually, you guard against, let's all face it, one of the problems here or common complaints is that what if a judge can be corrupted? What if he or she cannot render a neutral decision in a case? How do you safeguard that in arbitration?
Well, yeah, sadly, that is always a problem in the judicial or quasi-judicial setup. But in the IPO field arbitration, or even in any arbitration centers around the world, this is guarded by giving you the choice of appointing an arbitrator. If, for example, I am the litigant, I would choose someone with the reputation. I would choose someone that I trust. I would choose someone with expertise to rule on my case. So it guards you against possible corruption. But I would say also, I would like to emphasize that when you're appointing an arbitrator, you're not appointing a representative in a case. You're appointing someone that would rule on a conflict between you and the other party, and you don't expect that person to rule in your favor. So when you're appointing an arbitrator, make sure that you trust that person, whatever decision he may come up with or she may come up with, and the reputation must be impeccable.
I know, this is what I like about arbitration. You get to choose your judge more or less, but it doesn't mean that that judge is your lawyer.
Yes, that's true.
Yes,
that's true.
and that judge or arbitrator has to be chosen by both parties.
By the parties, yes.
What if you want him, but I don't want that judge to be our judge? It doesn't work. So we cannot choose that
there's
judge.
provision for objections. Like, for example, if your objection is grounded on some rules or some grounds that are, that is For example, there's a conflict of interest. You're appointing your own lawyer, or you're appointing someone who ruled on the case before this, or you're appointing an internal counsel. So of course that's very obvious. I, for example, can object to the appointment of the other party. Yes, but if, for example, if you're okay with it, they can go ahead. Yeah.
They can go ahead.
Yeah,
so
they
you
can
can
go
choose
ahead.
that arbitrator.
Yes,
slash
as long as the
judge.
parties are aware of it. Yes.
Yes, but you said earlier there are some specialists or intellectual property lawyers who are accredited as arbitrators. What if, they held, well, I mean, they were the counsels for this. I mean, these clients will they inhibit themselves for conflict of interest?
Well, yes, they should inhibit themselves. There are provisions in the law which will bar them from sitting as an arbitrator. But more importantly, there are no surprises in arbitration. As an arbitrator, before you are appointed, you're required to make a disclosure of anything that you think will have a conflict of interest on what you're going to do. If, for example, you think that you are related to anyone or anything closer to the parties, or if you were involved in any way to the conflict, in whatever way, you should divulge it to the parties. So they will be given an option to object to your appointment.
Yeah, for example, I'm an arbitrator. I'm a former counsel for McDonald's, and then they want to appoint me as arbitrator. I have to inform the other party that I used to handle this case, and there might be a conflict of interest, etc.
Yes.
But I mean, can people as young as us be arbitrators already? I mean, you have to be a certain reputation.
You have to be
for
a certain
lawyer.
reputation,
Yeah?
of course. Like, we have an age requirement. Unfortunately, I'm sure you're not going to be qualified there.
Are you? Are you?
No, but I mean, even if you're appointed, for example, with even if you become part of the pool with very minimal experience, it will be very hard for you to get an appointment from the parties. Like, for example, if I have a complaint, or if I have a case, I want an arbitrator who has more experience, or, as I've said, who speaks my language if I'm a scientist. So if you have very limited experience, it would be
To your
almost impossible. Yeah,
disadvantage,
to your disadvantage. It's going to be very difficult for you to be appointed.
When it comes to paying the salaries of the arbitrators, does that come from the Supreme Court or the IPO?
This is a private setup, so the parties would shoulder the cost. We did a research last year, and we discovered that if you do arbitration here in the Philippines, it's going to be very cheap, at least compared to the ones in the region. Well, of course, we cannot leverage, or we cannot compare ourselves with China or with big economies like London or US. But even here in the Philippines, the filing fee, when you're litigating a case that involves a huge amount, it becomes cheaper to do it through arbitration. Because, as you know, the special commercial courts in the Philippines, they charge a lot of filing fees now because of the revised system. And our arbitration fee right now, as we design it, as compared to them, it's very minimal.
So you still have to file, pay fees when you file for arbitration. But where do you pay those fees?
There is a basic administration fee, and that is handled by the PDRCI. We have a partnership with them. We are going to refer the case to them for arbitration, and our role here would be, number one, on the scrutiny of the decision. When you come up with a decision, we call that arbitral award. You cannot just release it to the parties. Our rules require them to submit the decision to us for review. I just want to say that the review is not meant to be an appeal procedure of the decision of the arbitrator. We don't have any power to tell them what to do. We, of course, just review the decision for purposes of ensuring enforcement or making recommendations, especially if there is an issue on national policy.
So it's just a check on whether the arbitral award that is drafted by the arbitrator is, in good terms.
In good terms, yes. Is it enforceable?
Is it enforceable?
Exactly.
Because have there been cases wherein the arbitral award is not enforceable, or is a problem? In the global history.
Yeah, in the Philippines, we don't have as much experience as that because, in the construction industry, arbitration is very, very famous. It's well accepted. In fact, it's even part of our rules of court right now.
It's standard for construction companies to go into arbitration.
To go arbitration, yes.
Because otherwise, that road is not going to get built, right? So,
Yes.
with trademarks, it's business, and time is of the essence. So that's why parties have to go to which body, the IPO or the arbitration?
They go to the IPO. They can go, for example, to us if they want, number one, a concern on writing their arbitration clause or entering into an arbitration agreement. If there is a case filed before the IPO, the system right now is they go through mandatory mediation. And when the case is not settled through mediation, they go back to the originating office. And the originating offices would tell them if they want to go to arbitration or choose the regular route. If, for example, they chose arbitration, I come into the picture, I explain to them the procedure, and then we prepare the arbitration agreement, they sign the contract, and we refer the contract to the Philippine